بسم الله الرحمن الرحيم.
سبيل الدموع سبيل مريح، تنهدى يا صاحي كي تستريح، وبث الدعاء الخفي الصريح، يسعك الفضاء الرحيب الفسيح. سبيل الدموع سبيل مريح، تنهدى يا صاحي كي تستريح، وبث الدعاء الخفي الصريح، يسعك الفضاء الرحيم.
نحمده ونصلي على رسول الكريم. Amma ba'd. Assalamu alaikum wa rahmatullahi wa barakatuh. And welcome back to part 2 of British Deobandi view on assimilation, integration, hatred, extremism and terrorism. We left you after the first part of the series of these lectures, once we'd explored the structure of this series, and we'd gone on to and also explained what the research was based upon. We'd gone on to definitions, and we spent a great deal of time on definitions and about how and what these are. I touched upon, because the focus in particular is the Deobandi view, and I touched upon how in certain circumstances how the Muslim has behaved, or the Deobandi approach has been, and we've seen that in certain cases it's been isolation. We're going to explore now the British Deobandi view is very different than the colleagues centuries ago within the Indian Deobandi view, and we see how that change occurs and why that change occurs. We touched upon isolation as well, and went into some detail as to the process of first of all how isolation comes about, and then the process which goes along. We finished on, or we just stopped on rather, on Sharia and Islamic law. And again, I do not have the time really within this series to be able to go into great detail about the Sharia itself and what it is. First, what we can say is that Islamic law, and I have used the word law, but I feel I need to define this. And the reason why I feel I need to define it is because law itself is very different. Now, we use the word Islamic law because that's something which we've become accustomed to, and it's something which people use to describe what the Sharia is. And what I will say, and the Sharia is obviously not implemented as the Sharia, it's the fiqh which is implemented, which we'll go into detail or at least explore later. So, what is a law? Well, a law by definition is a system of rules that are enforced through social institutions to govern behavior. So, let me just say that again. Law is a system of rules that are enforced through social institutions to govern behavior. Now, when it comes to the Sharia within the British context, is it that? Is it a system of rules that are enforced through social institutions to govern behavior? Well, no, it's not. It's not in that sense, because it's not enforced. That's the key point here. It does not have a police force. It does not have the judicial setup. It does not have anything in place in order to ensure, like say for example British law has, to ensure that it's acted upon. So at best, well, how do we define it then? We need somehow to define it. Well, the way we define it is that at best it's a moral code within this context. And what does a moral code mean? This is a written, formal, consistent set of rules prescribing righteous behavior initiated at the bequest of a person or group of people and accepted by them. So we can see that context also plays a part in what it is that we call those particular rules, because in both cases it's rules. In law it's rules, and in the moral code it's rules. So both are rules. We are following rules. The difference between law and moral code is, in law it's enforced, In the moral code, it's at the choosing, at the bequest of an individual or group of individuals who accept these moral codes. That's a marked difference. And I want to sort of really pause on that to reflect over what's being said here. That the moral code is how it should be defined. Even though we may use the word Islamic law, as it's not enforced, as there are no social institutes that are trying to force this upon individuals, it is at the bequest of the individual. So whether individuals go to a Sharia, inverted commas, court, okay, or whether individuals go to a mufti to ask him a question, the reason why they're going to that particular Sharia court, the reason why they're going to that particular mufti is because the moral code that he is following, or the system of rules, should I say rather, the system of rules he is following, or he or she has expertise in, this person wants to live their life according to those sets of rules. So this individual goes across to this court, and I use the word court with quotation marks, this court, as I can understand the impact of what I'm saying, but they go to this court, they go to this area, let's use that word, they go to this individual because he is an expert on the set of rules that this person wants to apply on their life. And the reason why they want to apply these set of rules on their life is again because of the effect of the belief system that this person adheres to, that this person has accepted. So because of the belief system that this person has accepted, his belief or her beliefs as a Muslim, then that belief brings about a certain set of rules that this person has to follow. Now, if they were living in a country by which Islamic law was the law, by which the law was based on the Islamic set of rules, then that country would have a means to enforce those rules. And as a result, you can use the word Islamic law to describe it there. But when we're talking about an area or a country in which there is no means of enforcing those set of rules, then those set of rules are called a moral code. So they're both the same, set of rules and set of rules, no difference. The only difference is as to whether this is a willing individual, whether this is an individual who by choice, by their own choice, by their own bequest, they've asked this individual and they accept those sets of rules. And in the first case, the law case, is that these rules are being enforced on this individual. So it's a key point to draw. So even if I use the term Islamic law, and I have used it there, we know that this is what we're referring to here is a moral code. That's what we're referring to here. So what we have here in introducing this concept is a set of rules which individuals adhere to and apply upon themselves by choice, but those rules are not enforced. And as a result, they can only be called a moral code rather than a law. What is this Islamic law, as it's being called, based upon? Well, firstly, it's based upon the Quran itself. And the Quran, a revealed text, the actual word of Allah, which contains over 6,000 verses, and some of these verses, a significant amount of them are legal verses, and those legal verses are utilized. The second source is the ahadith, which is the sayings of the Prophet ﷺ. And again, there's a large number of statements made by the Prophet ﷺ, his acts, his behavior, his statements, which have become a body to make the law. There is ijma, which is the consensus being built up in the absence of anything within these two sources, or when there's disagreement, either in interpretation or in terms of conflicting evidences in both these sources. And ijma, or as I said, in the absence of source, ijma can act as a law. And finally, there is what's referred to as qiyas. And the qiyas specifically is talking about syllogism type reasoning or analogical reasoning. Whereas in the more broader context, qiyas can easily be applied to reasoning full stop, because this is now developed. This area, or rather the area of reasoning, is developed, and so there's many other facets now to reasoning which goes just beyond the more basic and simplistic of qiyas. But again, this lecture series is not about usul al-fiqh, and as a result I don't want to go too much into this. But then I introduced it as a way to demonstrate what Islamic law is. So what do scholars do? Okay, well, scholars develop and bring about fiqh, okay, which is coming from the Sharia. So the Sharia is divine, it's protected, found in here, and the fiqh is coming about. It's being brought about by human endeavor, obviously legally qualified human endeavor, not just human endeavor full stop. And the fiqh itself, it varies, because it takes the text, and here I'm not referring to text as in the source text, because following a particular madhab, following a particular legal school, means that the text that's referred to here is the accepted texts within that legal school, which is based upon these. Because there aren't, I'm not aware of any individuals on the surface of the earth that have direct access to these sources and be able to derive rulings themselves, because all those rulings have already been derived and they've been put together. Apart from obviously new circumstances, when that's changing, and when the circumstances are changing, when Muslims are finding themselves in new circumstances, then you see that text isn't just applied blindly, but it's applied. Text plus context will give the fiqh, and that's really the focus and the reason why. And again, you can see the importance that context plays. So again, going back to our key topic and key discussion today, is the British Deobandi view on these things, rather than just saying, well, Deoband is a particular view and it's fixed, it's not staging. Its methodology, its approach is fixed, and that is to defend the Muslim identity against assimilation. That is fixed, and you will find that it tries to safeguard the Muslim's identity. That is fixed. But what isn't fixed is the way it can go about doing that. And the way it goes about doing that within the British context is very different than the way it went about within the Indian context a couple of centuries ago. And that's what I turn to next, is the role of context, and how does it play. And I've sort of jumped the gun a little bit there, because I've already defined the law well within the last slide, so I don't need to repeat myself here. And I've also defined the moral code. And the reason why I'm mentioning them here is because why is it that it was called law in one case and moral code in another, when they are both sets of rules? What's changed? They're both sets of rules. What's changed? Why call it law sometimes, and why call it moral code? Because it's the context which means it's called a law, and it's the context which means it's called a moral code. So where there is political authority, where it's a Muslim majority state, and this, I'm not talking Muslim majority in terms of population, but Muslim majority in terms of political power, then it is a law, because the Muslims have the ability to be able to enforce it. When it's not in that environment, when it's an environment where the Muslims are a minority, not necessarily numerically, but in terms of political power, then it's a set of rules, but it's a moral code, because there's no means of enforcing it. Hence you see in the books of fiqh talking about, does riba exist outside of Darul Islam? Do certain sins, are they still considered as sins outside of Darul Islam? Well, the question would come, why is it riba irrespective of where you find yourself? Whether you find yourself in a Muslim dominant environment, or whether you find yourself in a Muslim not dominant environment. Why is a sin a sin? Something which is illegal is something which is illegal. The reason being is that outside of that area, it can't be enforced, it can't be legislated. And as a result, because it can't be enforced, it can't be legislated, it doesn't come under the definition of law. It comes in the definition of a moral code where individuals at their own free will and at their own choice go forward and accept that particular position by discussing it with experts of those sets of rules. Let's look at a few context examples. Consumption of the illegal. I've already gave one example there, which was the concept of interest outside of a Muslim majority or Muslim powerful or Muslim power-based country. Other context examples are the consumption of the illegal. You know, it's obvious to everybody that eating a ham sandwich for a Muslim is haram, it's illegal, it's impermissible for him to consume that. However, that's in what we would consider a normal context, in a normal situation, where he has access to other foods, where he has the ability to consume halal food. I don't mean that, you know, he has to be forced to become a vegetarian, meaning that there are other foods he can eat. He's not required. So as a result, in that context, it becomes illegal for him to consume it. However, if he's in a situation where he is literally about to die, or is well on his way of dying, or his bodily functions, his organs are sort of shutting down, and if he doesn't take any type of food on board, any nutritious food on board, he's potentially going to put himself in such a situation that he will not be able to recover from, or worse still, he could lose his life. Then the law, if I can use that word, the moral code, permits him, rather makes it compulsory upon him to consume the illegal. Well, how can the illegal become legal? Because of the context. Okay, the context changes it. Washing of arms in wudu, another example. We know that it's compulsory to wash 3 parts of the body and wipe the 4th part of the body, and these are compulsory. But what do you do in the absence of not having arms, say? Well, in the absence of not having arms, then it becomes compulsory to wash 2 parts of the body and wipe the 4th. So you can see that both within, you could say, ritual acts, and also which you would consider to be mu'amalat, sort of the normal sort of behavior, human activity. You can see that the law, the Sharia itself, as understood as it derived through fiqh, gives a different position than it would have done if the context had been somewhat different. So that's really highlighting the concept that the role of context, rather, within the Sharia and how it's understood through the fiqh. Let's look at another example. Okay. Let's look at another example, and this is looking at a particular area. And this area is looking at a discussion that's taken place, and there's a reference there, and you'll find most of these references in the bibliography of the book for further reading. You find that in the case of permissibility of hiring someone for teaching the Quran, the legality of sale with a right of redemption, and dependence on circumstantial evidence as in accepting testimony of marriage concerning a couple who behave towards each other as a married people do. Now it says earlier jurists did not allow such matters. So this is the development within a school. And this is a legal development within a school. A legal development within the school is ijtihad. And an illegal development within the school is a bid'ah. And it's knowing, and it's obviously the legal experts who will be able to define what is a genuine legal development within the school and what is an innovation, what is an act which was made impermissible. So these 3 particular acts, hiring, paying somebody to teach the Quran, looking at the legality of this type of sale, and taking circumstantial evidence into consideration to prove that somebody is married, weren't permitted in the early stages. However, things changed. So what is it? It said the Quran was to be taught free of charge. But there was a reason why the Quran was to be taught free of charge, and that's because teachers were paid by the state. So no individual had to have his own students, so therefore he would teach it for free. the students would benefit from him, and the state would provide a stipend, and the state would provide some money for him in order for him to be able to look after himself and his family. But once the state stopped paying, which is what we see here, once the state stopped paying, then what happened was the scholars, or those who were the teachers, no longer were in a position to give their time freely to teach the Quran. So what they decided to do was to take up other preoccupations in order to make ends meet, and stop teaching. As a result, obviously student numbers went down, and as a result the knowledge of that particular science was being lost. So jurists then gave the view that because the context has changed, because initially the context was such that they were receiving money directly from the state and there was no need to pay them, the situation now changed. And this was even though there is narrations which categorically speak against this act. And a sale with a condition negating its finality could not be made, because a sale by definition is the exchange of a price with a product. That's what it's there for. And if you put any condition on a sale in any within buyu, and that condition is such which is stopping it go through, then that condition is removed. Why? Because it's not allowing the process of sale to go through. And the whole point and the whole reason why these two individuals are partaking in this activity is because of a sale. And finally, accepting circumstantial evidence in a testimony of marriage, one saw at a time was because this was evidence was only by the defendant's unwillingness to take an oath denying the claim. That was the only other option. And when that option was no longer available, then there was no alternative. We move on to role of context 3, as in the next section within the role of context. And here we find within Rad al-Muhtar talking about this very same thing. So he says, and I'll read it out in total. So with respect to all these issues, whose ruling changes due to the changing times. So obviously what's happening, time itself doesn't change, people change. So what's going on? Meaning changing times in what way? Because of necessity. Okay, it's now the way people live their lives is in such a way where now out of necessity a person has to behave in a certain way. Or urf, and urf you're talking about sort of societal customs that are taking place. Or qara'in al-ahwal, sort of context, circumstances, surroundings, whatever, words to that effect. Because of these issues, okay, because of these circumstances, because of these, you're starting to see that ruling can change due to the changing times. Now, if these rulings change, he then categorically says that these rulings are not outside the madhab. Because if the Sahib al-Madhab, yani the Imam Abu Hanifa in this case, was in this era, he would also say the same. And had this change occurred in his time, then he would not quote against it. What he's saying here, Ibn Abidin rahimahullah ta'ala, is that we are applying the school. We are applying the methodology of the school. And the methodology of the school is the same, even though its position can change. And I want to, at this juncture, hark back to the introduction of this whole series, which was British Deobandi view. And this has been either intentionally or unintentionally missed by commentators of the Deoband and media individuals, reporters, with respect to Deoband. And the way they've perceived it is that Deoband has one position irrespective where they find themselves. That couldn't be further from the truth, because the Deoband practices the Hanafi fiqh, and they are experts within the Hanafi fiqh. And being experts within the Hanafi fiqh, they know very well that when the situation changes, okay, when we are in a different circumstance, and you couldn't get a further and a more different circumstances than the British Raj of India, and now Muslims within Britain, you're going from a position of power, because prior to the British arriving in India, the Muslims had authority, had power within India. So you're going from that situation to now, and there the British arrived not by request, but by sort of pushing their way in, to the situation we find ourselves in Britain, where the Muslims are as a minority, and they came by choice to live within Britain. So the circumstances are completely different. Therefore, we would see that even though the method, the maslak of the Deoband is the same, it hasn't changed. So people might say, well, yes, but the same textbooks are being taught, the same methods of teaching exist, so nothing has changed. You've got the same sort of teachers, the founding fathers who came over from India, so you've got the same sort of teachers who are teaching, nothing has changed. No, that's the point is being misunderstood. The maslak hasn't changed, the methodology hasn't changed, absolutely. And the methodology is just a manifestation of the Hanafi madhab. It's no different. That hasn't changed. But the results will change. Because again it says these rulings are not outside the madhab, because if the Sahib madhab was in this era, he would also say the same, and had this change occurred in his time, then he would not quote against it. That is what has encouraged the mujtahidun fil madhab, those individuals who are experts and who strive to make ijtihad within the school due to new circumstances, and the people of correct opinion from the latter scholars in opposing the texts from the Sahib al-Madhab in the books of Zahir Riwayah, which are established upon that which was in his era. So bringing this down to a more macro scale, what we're saying here is that just because we find certain fatwa within the textbooks, within the text of the Indian ulama, of the Deobandi ulama, that would now seem quite problematic within a minority context, does not mean that those fatwa are passed then within a minority context. They are not, because it would mean that you are actually going against the methodology, even though you're sticking to the rulings. And the methodology is what's fixed, not the rulings. The rulings can change, the methodology can't change, because the methodology is tried and tested. So that's the point that needs to be understood. So one may ask the question, well, what's the point? What's the point in keeping hold of textbooks or keeping hold of books of scholars who were writing in a very different context, where the British were seen as an aggressor? Why keep those books? Because through those books we understand the methodology. And by losing those books we lose the methodology. And the methodology is important to retain that practice and that purpose for Deoband, which was to prevent the Muslims from being assimilated. And as we move further and further within the technological era, this era of moving so fast, where religiousness is seen as backward, where spirituality is seen as irrelevant, where giving any alternative position for existence of humans on the surface of this earth is laughed at and mocked. Because there is this open, aggressive atheism that exists, then not only is Islam as a religion and as a practice under attack, you could use that word, but so is Christianity, Judaism, and any other traditional religion. So what the Deobandi approach was to safeguard the Muslim community from being assimilated and losing their identity. And that's exactly the methodology that they approached, and took, and different rulings existed when they were in a different environment, and now different rulings exist within the British environment, which is what we're going to discuss in great length as we move across. But before we move on to the next topic, and the next topic explores the political legal jurisdictions, which is somewhat of a mouthful, I think we can stop there for this part and pick these discussions up again in part 3. I hope you can join me. Assalamu alaikum wa rahmatullahi wa barakatuh.
يسعك الفضاء الرحيم